Over the past few lessons, what we have done is spend some time talking about the various different preliminary considerations that are required before a dispute can be brought in litigation. We've focused on some of the alternative dispute resolution proceedings that may need to be required before you, or at least it should be shown that you have a good faith understanding that you wish to bring those cases at the immediate juncture. But there are also preliminary considerations like things concerning limitation, things like a correct course of action, things like a certain a way of identifying parties to a claim. This lesson is going to, and the next lesson is also going to talk about the idea of these pre-action protocols. We will talk about the sort of general guidance for the pre-action protocols in this video, and we'll do a quick case study in the next video on pre-action protocols concerning specifically judicial review claims. And I'll explain what I mean by both of these different ideas throughout. So we're still on the preliminary considerations section of the SQE specification. The last video spoke about limitation. This video is going to think about the pre-action protocols. And ultimately, we'll examine what essentially is the pre-action procedure that is necessary for preliminary considerations at the beginning of a civil dispute case. And the pre-action protocols, as we will read some of the sort of basic rationales for them in a second, fundamentally adhere to this idea that we have been thinking about throughout these lessons concerning the fact that ultimately we don't want litigation. Essentially, litigation ought to be avoided at all costs by as many measures, as many means as possible. And the pre-action protocols reflects this rationale, thinking about all the things that could be done before you need to resort to litigation. And that's because everybody sort of has collectively recognized that litigation is expensive, it can be unpredictable, it takes a long time, and it can also clog up the civil justice system if there's too many people very quickly jumping on the idea of litigation. So resolving these disputes amicably or resolving it in a more, or at least should I say a less formal way, has always been encouraged. And that is the sort of fundamental underlying rationale that you should take away from these ideas of preliminary actions. So there are a number of pre-action protocols that exist for a whole host of different civil claims. There's about 10 or 12 that relate to different claims. Some of them are quite niche, some of them are quite broad, but there is also a pre-action protocol that is a sort of general practice direction, which we'll talk about in this video. Ultimately then, so you have things like pre-action protocols for claims concerning debts, claims concerning personal injuries, claims concerning breach of contracts. The textbook, the main textbook for dispute resolution, spent some time doing a couple of case studies for some of the more common pre-action protocols. I decided to do something similar by focusing on a different pre-action protocol, specifically the judicial review pre-action protocols. Where there is no such protocol that exists, so let's say it's a claim that just does not have a pre-action protocol associated with it for a particular claim in question, then there is a more general one which exists in what is known as the practice direction conduct. This is what we'll explore in more detail here. So you sort of have a general pre-action protocol, and then you have, or at least a general practice direction, and then you have a whole host of protocols that are associated with specific claims within civil litigation. Now, they all generally refer to the same thing, but of course they might be tweaked and altered to depend on the suiting of the needs of that particular type of claim, of course. So the introduction of these directions sets out clearly the rationale and the intention of the practice direction. It says that pre-action protocols explain the conduct and set out the steps the court would normally expect parties to take before commencing proceedings for particular types of civil claims. Again, the kinds of things that you ought to do before thinking about, or at least a court expects you to do, in most cases at least, before the proceedings are commenced. This practice direction applies to disputes where no pre-action protocol approved by the master of the rolls applies. So again, the practice direction is concerning general claims to which there is not a specific pre-action protocol. So the objectives then clearly are set out by the practice direction, and they outline what the court would expect each of the parties to do and what they should expect each of the parties understand about each other, and also try and show evidence of mitigation before bringing a claim to a civil dispute. We'll talk about mitigation in some of the other areas of law when we talk about torts and when we talk about contracts, and in fact later on in this series we'll talk about mitigation as well. But ultimately the idea of mitigation is that you shouldn't, if you are an aggrieved party, let's say you are a claimant in a civil case, you shouldn't do all that you can to maximize the damages of your particular claim in order to get as much damages as possible. You should mitigate the damage that has occurred onto you in order, and then claim for damages of what is left, essentially. The idea is you shouldn't really milk it, is essentially the general rationale from a non-law perspective. Now, the objectives of the practice direction and the pre-action protocols are found in section 3 of the practice direction, and it outlines that parties are expected to have and to have exchanged sufficient information to both understand each other's position, to make decisions about how to proceed, to try and settle the issues without proceedings. Remember, that's the part that I'm focusing on in terms of the fundamental rationale for civil litigation, that at every step of the way, it is encouraged that you settle the issues without further proceedings, or potentially without proceedings at all. This is why most disputes, by the way, don't go to court. Also, to consider a form of alternative dispute resolution to assist with settlement, to support the efficient management of those proceedings, to reduce the costs resolving the dispute as well. So those are the kinds of things that both of the parties should have exchanged information concerning, okay? And notice, like I said, illustrating the fundamental rationales, illustrating the clear desire on the part of everybody to avoid litigation, 2 of these clear issues concern alternative ways of resolving the dispute, settling the dispute without proceedings, and considering forms of alternative dispute resolution to assist with settlement. The practice direction then outlines the appropriate steps to be taken with regard to the implementation of paragraph 3 as well. So it lists all of these different things that should be known to both of the parties about each other. There should be an exchange of sufficient information to understand each of these different kinds of things, to support efficient management, to reduce the cost, to try and settle the dispute, to make decisions on how to proceed. And then there are also the appropriate steps that are necessary for the implementation of paragraph 3. So, for example, quote, the claimant writing to the defendant with concise details of the claim. The letter should include the basis on which the claim is made, a summary of the facts, what the claimant wants from the defendant, and if money, how much of an amount or how the amount is to be calculated as well. The defendant responding within a reasonable time, usually this is 14 days in a straightforward case, and when it comes to very complex cases, it can be no more than 3 months. The reply should include a confirmation as to whether the claim is accepted, and if it is not accepted, the reasons why it is not accepted, together with an explanation as to which facts and parts of the claim are disputed, and whether the defendant is making a counterclaim, as well as providing details of any counterclaim. So in some circumstances, you might be a defendant who gets a litigation letter, maybe a cease and desist or something, and you might think, well, actually, I have a claim myself. I'm going to issue a counterclaim. And so that has to also be included in your response to the claimant's letter in the pre-action protocols. And then finally, the parties disclosing key documents relevant to the issues in the dispute as well. That is also a requirement. I want to continue by just thinking about the appropriate use of the protocols. So the practice direction is very clear to note that these pre-action protocols ought not be used for tactical purposes or for reasons that are not for fundamentally resolving disputes as quickly, as efficiently, and as cost effectively as possible. So it should involve the taking of only reasonable and proportionate steps. And this also applies where the costs are incurred in compliance with the pre-action protocols as well. So all of these things need to be taken into account, that you have to, if you're going to reference the practice direction, if you're going to reference the pre-action protocols, you have to do so with clear indication that you are doing so for appropriate reasons. You're not doing so for reasons that might be for some kind of ulterior motive, and should only be used for the taking of reasonable and proportional steps in the event of a dispute.